Welcome to Mandoo 2. Today, we are covering a deeply disturbing bond hearing case that will shake you to your core. Imagine a 12-year-old girl, pregnant. The father? The father turns out to be her stepfather. But there's a twist. The twist is that mom knew. She knew before the pregnancy, during, and after. Yet shockingly, she still stands by this man. This isn't fiction. This is a real case we're about to witness. We'll take you through the bond hearings for both the stepfather and the hearing for the mother. And these hearings are presided over one of my favorite judges, the Honorable Judge Stevens. Now prepare yourself for a case that challenges everything we believe about parental protection and justice. Stay tuned as we delve into this heartbreaking story of betrayal, abuse, and a system struggling to right these wrongs. With that, let's jump in.
Let me ask, are you Joshua Booker?
Yes.
Mr. Wilkerson is your attorney right there? He's appearing through Zoom. Hey, I'm looking at this motion from the state.
Yes, Your Honor. Yes.
What you're alleging is he's committed a crime.
Yes, sir.
What are y'all doing about that?
We're
The
gonna
new
look
office,
into
I mean,
filing
we're gonna have a
that.
trial if
Yes,
y'all are gonna come forward with more than indictments. Go ahead.
Yes, sir. I believe it, at the very least, it's a misdemeanor threat. So we'll see about getting that filed. I have to have somebody go out and talk to the uh, victim in that case that the threat was made to.
I don't know that a terroristic threat couldn't necessarily be made out because of his ability to commit or not commit an offense if the government's evidence is indeed substantiated. Um, I'm not sure about a retaliation uh, case, though.
No, this states that the defendant sent messages promising to kill the father of Paige Davis. Who's Paige Davis?
That is second.
Killed somebody. That is. Let me speak. Well, that's a threat that's an illegal act. I mean, I'm sorry, that just doesn't fit within the freedom of speech when we're talking. And how does it affect a pending case? How does, is that involving this case? Is the threat directly related to this aggravated sexual assault of a child charge?
No, sir. That threat is not. It's to another individual, but he's just using those communications to threaten not only via the kiosk messages, but also then admitting that on the jail calls, calling these individuals, continuing to speak with them.
Okay.
But there's also been three-way communication between where the defendant calls Geraldine Davis or Paige Davis. They all live in the same household. He's calling them, and they're then three-waying with the other co-defendant, Danielle Davis, and they're on the phone together with that as well.
Okay. So what are you asking for?
For the court to essentially not allow them to be able to use the jail communication to communicate with anyone outside of the jail until we, yes, sir, Your Honor, go to trial on.
What do you say, Mr. Wilkerson?
Your Honor, Mr. Booker has been locked up pending trial for quite some time. He's currently set on $150,000 bond. Judge, we had filed for a reduction in bond to try and allow.
Oh, no. What's one catastrophe at a time? The motion to prohibit defendant's jail communications. What do you say about that? Let's take that one. than the other one.
Judge, we have no objection to that.
Well, that will be done. We'll have no access to communications from outside, communications that go outside the jail. Do you understand? Also, the state can pursue whatever additional charges they wish to make. Plus, this is the kind of evidence that at a trial gets to come out. And that doesn't help you in your situation. Juries don't ever find that amusing. But we're adults here and you can make, you have freedom to make choices, even poor choices. So you are hereby ordered to have no access to communications through the jail system or any other method of communications outside the jail itself.
We would ask Judge that communication with his attorney or attorney's office be excluded from that.
That isn't allowed. That's the only exclusion. But here's the problem with that is how do we monitor that? Because people aren't going to be listening to that. They shouldn't. That's confidential. But what's to prevent him from, while confidentiality is going on, getting calling somebody else with the proposition that it was to call you?
I'm not sure if the system is able to limit phone numbers dialed or not, to be honest with you.
But Marcus, if it's not, you're gonna have to just go see him in person.
Yes, sir.
All right. That's what I want to do, because unless I'm certain, and he's lost his communication privileges.
Your Honor, I was just informed by Captain Minter from the Jefferson County Sheriff's Office that the defendant could go through bookend via Zoom call to his attorney to communicate that away. So they would provide that, but he would have to go to bookend to have that call
Do
with
you
his attorney.
understand that? And that's the only way you're gonna be able to talk to him, is to request to go through bookend, to call him. Otherwise, he's gonna have to come see you, which are privileges you have lost. The jail is going to be able to monitor this if there's any determination made that he is outside the rule, the order of the court, which is no communications, phone, text message, or otherwise to any party outside the jail. Then the court needs to know. Also, I asked the state to look into any additional charges that
Yes, sir.
when people are threatening from the jail, that's forbidden.
Yes, sir.
It's forbidden to threaten anybody, much less being in jail and being able to communicate disturbing messages. That's irresponsible, but it's forbidden. What else, Mr. Wilkerson? Those will be the orders of the court. So what do you want next? Go ahead.
Well, Judge, so our motion was for a reduction in bond before these issues were ever raised. I feel like the court through GPS monitoring and house arrest could be able to fashion rules that would essentially prevent issues like this from occurring in the free world as well. But still allow Mr. Booker to secure a bond to be able to, he's expressed interest in hiring a different attorney. Of course, he has no way to make money while he's locked up. And he apparently had been receiving some benefits that, of course, have been stopped because he's currently in jail. So
I want you to explain to me how in, let's say a home confinement with GPS, how that is more restrictive and secure in preventing disturbing, threatening messages to others than the jail is.
It's not, Judge.
Can't prevent it. You haven't been able to articulate to me any reasonable method that being outside the jail, we could prevent this from happening.
I would agree with the court that it's not more secure than a corrections facility, Judge.
Saw what happens, what has allegedly happened here. Threats have been made to kill people from the defendant while he's been in the jail. It certainly is not going to be more secure out in the free world to prevent disturbing messages like that are criminal in nature. Even it may be a misdemeanor, it may be a felony, but it's still a crime.
And Your Honor, I,
Threaten to kill people.
I'm sorry. I do have,
And then if you're using interstate commerce, that's probably a federal crime.
I do have the text messages that he sent through the kiosk where he's promising to kill the father of Paige, and they all live together too, is my understanding. The Paige Davis, her mother, Stephanie Davis, as well as Geraldine, her sister. So he's promising to kill Paige's father, Stephanie's husband. They all live in the same house over some money. And so the state believes that the bond, if anything, would be increased, but certainly not reduced in this case.
Okay, what else?
That's it from the state.
Well, I mean, you've got something in your hand.
Oh, yes,
It
Your Honor.
has to
I
be
do have
put into
these. I do
evidence.
have
You wanna
these.
put something into
Yes, Your
evidence?
Honor. I'd offer states 1, 2, and 3. These are the kiosk messages that were sent from the defendant to Geraldine Davis. Again, that's the sister of Paige Davis. There's also a jail call, if you want, where he admits to making the threats to Stephanie Davis, the wife of the individual that he was threatening.
All right, have you seen these?
Your Honor, I was provided a copy of the 3 kiosk messages as well as a recorded phone call.
All right.
Um,
Any objection?
I do still have to object to their hearsay nature for record purposes, Judge, but I have received copies of them.
Okay. Okay, what's the hearsay nature since he's the defendant?
It hasn't been proved up that their storage on this third party facility hasn't been proved up. Him having been the one sending those 3 lettered messages hasn't been.
I do have
Sure.
Captain Minter here to prove that up, Your Honor.
All right.
Yes, sir.
Call him.
Your Honor, state Captain Bruce Minter.
Come
the
forward.
County Sheriff.
Sir, just have a seat right over there in the witness box. Thank you. Come on up.
Judge, also I need to point out under the record that under the rules of evidence on the bond reduction, which is what we're talking about here, the rules of evidence don't apply according to the rules of evidence.
I'm sorry. The application of reliance and reliability always apply. Come on up. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand, sir. Thank you. Go ahead.
Please state your name for the record.
Bruce Minter.
And where are you currently employed?
I am the captain of records and technology with Jefferson County Sheriff's Department.
And when messages did the inmates there have access to send messages outside of the jail there?
Yes, they do.
And are you over that system there?
Yes, I am.
How is that recorded? I mean, is it uploaded to something or how is that?
Everything is recorded to the cloud. That Smart Technologies is over. Everything phone calls, everything they do, pictures, postal mail, everything goes through Smart Technologies.
And so it all goes through there. Does it identify any individual sending them?
Yes, it does.
And does it identify who those individuals are sending the messages to?
Yes, it does. When an inmate comes to jail, they have connections that they make.
connections are verified, approved through either ID or driver's license and photo to confirm that the person they are speaking to is that person.
So you know who the inmate is sending their communications to.
Yes,
Now, is that system secure there?
it is very secure.
Is anyone is pretty much restricted on who can access that?
My superiors.
Now, showing you what's been marked as State's Exhibit 1, 2, and 3. Do you recognize these?
Yes, I do.
And what are those?
Those are text messages sent from the inmate to an outside public user,
And who's the inmate there?
Joshua Booker,
And who did he send that to, these messages?
Geraldine Davis.
And were these downloaded off of the system there and recorded on that system?
Yes, it was.
And are these a true and accurate copy and representation of the messages that were sent?
Yes, they are.
And Your Honor, I would offer State's Exhibits 1, 2, and 3, ask that they be admitted into evidence.
No objection, Your Honor.
Without objection, they are admitted for this hearing.
And
Anything else from the state?
no, Your Honor, that's it. I have
From
no further
defense,
questions.
go ahead, Mr.
Uh,
Webber.
no questions for this witness, Your Honor.
Okay, and,
I would just offer States 1 through 3 to the court, Your Honor.
okay, and in this, this says Joshua Booker, is that the same man we're talking about?
Yes, sir.
Here, in this case, the Joshua Booker, who's in this courtroom here charged in 23 CR 1490 with an indictment alleging aggravated sexual assault with a prior conviction of assault of a family member out of 2014, which is an enhanced first degree felony offense.
Yes, sir.
Same person. All right. Anything, Mr. Wilkerson, anything else?
No, Your Honor.
Okay, can Mr. Captain Minner be allowed to be released? He's got important duties.
Yes, sir, for this part of the hearing, we have another hearing where he might be needed
Okay,
to come in
well,
right
stand
after
by.
this, but
Thank you, sir. What else from the state?
Your Honor, the state just again believes that nothing else to present other than we just would argue that it shouldn't be reduced to bond.
Okay, Mr. Wilkerson, what do you want to present? Any additional information for
No, Your Honor.
this hearing as well as your hearing to reduce bond?
I would call my client for the limited purposes of testifying regarding accessibility to funds and bond.
Okay, he's he's on the witness stand right now, and we're gonna turn the camera a little bit so he can be clearly seen. Well, if they just. That, I think it's that camera right there that we're talking about, and it just shows part of the defendant, but
Thank you, Judge.
there we go. Thank you. Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing, Mr. Booker, shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Okay, go ahead.
All right. Mr. Booker, are you the same Joseph Booker who is currently under indictment in this case?
Put the microphone please closer to his voice and move him closer, Tommy. Thank you very much for that. Is that-
And at present, Mr. Booker, you have a $150,000 bond. Is that correct? I presume he's answered. I can't hear, Judge. So, and Mr. Booker, are you able, through selling any assets, borrowing funds, or raising funds through family members, able to satisfy the requirements in order to make that $150,000 bond?
Well, the only way that's, I cut the restriction off, the only way I'm able to make it is through Paige Davis, because she has my debit card. That's the only contact that I have to make, like, to get outside contact with over. And Mr. Wilkerson, when you came to see me the other day, I also have 8 months on whatever happened since last month, whatever. So that's the only way I can actually get up out of here, because I have money now, she have the access to the money, that's the only way I can get access up out of here is by her through the money.
Why are
Okay.
we, why is he still paying for a ankle monitor if he's in custody?
Because, Your Honor, I had got,
Do you know?
yes, well, I had got the 8 months last month, we had a bondman that was gonna farm me out, but the lady said my bond was too high. So she didn't want to mess with me, so what it was, I was bonding out to a bondsman in Houston, and it was gonna work with me, so I just made a payment, kept making payments. Everything for 8 months, I have it on, but Mr. Lucasson came Monday, he also seen it on, so I does have 8 months on right. That's all.
Okay.
Finally, I do Davis because I have funds at they place where they have a debit card and everything, so that's the only way I actually like feel about it. Is to her, because she does have access to the money,
Okay.
things like that.
That's one way to spend money. But an ankle monitor while you're in custody seems to be an awful waste. Until such time you can get out of custody, but that's a decision that people are making who pay. I couldn't-
So, Mr. Booker, then is it your testimony that you would have no additional way to secure funds except through the communication that's now been prohibited by the court?
Yes, sir. I mean, that's the only way. I mean, not you can, I mean, there's really the only way, sir, is by her, whatever, because at the time of the point, I mean, I mean, I can't, I took the phone privileges, so I can't get in contact with anyone like my grandmother, I can't get in contact with anyone, so that's the only way.
Judge, I'll pass the witness.
Go ahead.
Mr. Booker, are those phone calls there pretty expensive at the jail?
Yes, it's like $3 a call.
Are you aware that,
Hold on. Is it unlimited time when you
No,
call?
no, it's 15 minutes.
15?
Yes.
Oh, $3
Yes.
for 15 minutes?
Yes. I've been using, that's.
I'm just always curious about that.
I'm using my money sometimes. Like money on there, she be using her money, like at times put money on there on the phone, and when I need commissary, that's.
Well, it's a privilege. A phone call is not a right, it's a privilege, but privileges can be abused. Like what happened in this case, and you lose the privilege, my goodness sake.
Mr. Booker, are also the kiosk
We have a Biggin raid, so I'm going to come up and just say hello. I don't normally interrupt. If you're watching this and you're for the first time, we're doing a live stream, and I just want to say welcome, Biggin family. Thank you so much for streaming in. For those of you who don't know, Biggin is a YouTuber that I just adore. One of the good ones, a special human being who, when I first started the channel back in the day when I had maybe 100 subscribers, he reached out to me, took me under his wing, told me all the tips and tricks, and even premiered Mandoo on his channel. And he now all the time sends over the stream. So I love Biggin, and I love all of you from the Biggin family. Thank you so much for being here. We're watching just an astonishing case, really, that will just blow your mind. It's still in the early stages. If you're coming, stick around, because we're going to see really a monster, a stepfather, if you want to call him that, who impregnates his 12-year-old stepdaughter. And if this can even be worse, if there's such a thing as worse, the mother, who we're going to see as well, defends this monster, if that is believable or not. And then I have information that Sir Richard shared that we'll go through the details of the crime. If you can believe it, this man, what he has done, what he's doing now from jail, there's actually more information that I'm going to share at the end that will just blow your mind. And I don't know if Sir Biggin is here in the audience, but thank you very much. And if one of you beautiful mods can drop a link to his channel, if any of you are not already subscribed to him, check him out. One of the good ones out there. And with that, let's jump back in.
messages, are they pretty expensive?
Yes, I think they like $3 or $4 a pop, I'm not mistaken.
Are you aware that you've made around between commissary and phone calls, around 6,200 phone calls.
Yes,
And also,
Wait, that's at $3 a call?
yes.
yes, sir.
Yes,
$18,000 in calls?
Yes.
Almost $20,000?
yes, the whole time I've been incarcerated, I've been having money to get up there. My bond get so high.
May I ask, who's paid $20,000? Who's coughing up the money?
Like I said, I get Social Security check a month on first and the third, and then she also was. Paying.
Hey, I get a social security check too. I couldn't pay 20 grand on a social security. I make a lot in social security because,
Yes.
but maybe. But we're talking, the most you can make is about 40,000
Yes.
to 50,000 a year. And, okay, but 20,000 of that has been used for calls?
Yes.
Now, Mr.
Okay.
Booker, is that all from your card?
It's not just from my card, it's from my card, so.
What's another, well, if she had referred to John's card,
Yes,
whose card would that be?
It is, I had something for her, that's my dead son that I have for her. So it's a cash out card, she just ordered a card, we cash out for her name on it, and then add it for his.
Thank you for the memberships,
So
Dame
she
Piglet.
should
Thank you so
transfer
much.
my debit card to her cash out card for the other.
Were you ever receiving funds from another card that was supposed to go to Malaysia?
Yes, I was, but I mean, the card that I was receiving it was supposed to go to Malaysia. I mean, I don't know what's on with that part.
How were you receiving those funds?
Because of the second fact, I think she gave the card to, the other card to her to keep whoever.
And so the card from Malaysia, you've been using that for commissary and stuff sometimes?
Some. Yeah, because he also sent that yellow money also.
Your Honor, I'd also note that that is the victim in this case, the 12-year-old victim, that the money was supposed to be going to. And so we'll have. people look
Articulate
into that.
how that worked.
Mr. Booker, and correct me if I'm wrong, that Paige Davis has access to a card that's supposed to be receiving money for Malaysia Davis?
Yes.
And
Wait, who's directed that the money is supposed to be for Malaysia? Is Malaysia, that's the child, right?
yes, Your Honor, and I believe it may be for, is that for child support
Yes.
from her father, Gregory Rhodes, was it? Okay, so child support is supposed to be going to this card, Your Honor. Paige Davis has access to it via Danielle Davis, the co-defendant. Is that correct, Mr. Booker? And Paige Davis has been, I guess, has she been splitting that money between you and Danielle?
Yes.
So the child support that's supposed to be going to Malaysia Davis, the victim, has actually been split between both the defendants in this case.
All right. Then I'm gonna request that the district attorney's office communicate to the judge whose orders were made in that particular case, ordering that money. So that the judge, I guess it's a family court matter. Was that a Jefferson County?
I believe the father lives in Newton, maybe?
I know, but where did the
but
proceeding?
I believe, yes, sir, it was here in Jefferson County.
Okay, so they're right down the
Yes, sir.
hall. Yeah, but in all fairness to them, they need to know because they're very sensitive, like all judges are. When we make an order, we demand and expect that it be followed. And those who don't get held severely accountable for it, especially when we're talking about money ordered by a court to a child. When that is being intercepted by third parties and being funneled to parties who are not the ordered recipient, that's criminal. And it's certainly an order violation that can hold people in contempt who are involved in that. I asked that the district attorney's office, please, in all fairness, get the judge and the parties in that case, who were the attorneys, aware so that they can act. Because what's happening is illegal acts are being run through the county jail now.
Yes, sir.
And I know the jail personnel are very sensitive about security and
Yes, sir.
ensuring that all the rules are followed. And it's done in a surreptitious manner that needs to be stopped. And we're going to try to help the jail officials do what they can to prevent further wrongdoing and criminal behavior while inmates are in custody.
Yes, sir.
It's not surprising. It can happen. But this is a real creative method of bypassing the rule of law and committing criminal acts while in custody in jail by people. This is blossoming into a very large net of criminal activity where people are becoming inculpated, that is involved in what I'm hearing in criminal behavior, and it needs to, number one, be stopped. Number two, the people involved need to be held accountable by law.
Yes, sir.
And I'm not, nothing surprises me anymore, but it's something new.
Sir. I have no further questions, Your Honor. from witness.
Anything, Mr. Wilkerson, from the defense, for the defense?
No, Your Honor.
All right. Okay, what are y'all asking for, lawyers? Let's summarize. Well, Mr. Wilkerson, you've asked for a reduction in bond.
Yes, Your Honor.
Summarize why that is worthy under the evidence I've just heard in this hearing today. I've only worse news. You've got to admit, I've only heard worse news. about-
I- Judge, like I said, this motion to reduce bond was filed prior to the defense becoming aware of all of these allegations. I cannot argue that there would be circumstances whereby he would be released that would be more secure and preventing communication than a correctional facility. I would say that I believe there could be restrictions put in place that would effectively limit his ability to make those communications while still allowing him to make bond in the case. But Judge, it was set at 150,000. We're asking for a reduction by half to 75.
Your Honor, the state just believes based on the defendant's statements, he has access to the money to bond himself out. He's spent probably around 18,000 just on the between jail calls and commissary that he received on there, as well as there's lots more kiosk messages that were also very expensive. And the defendant is continuing to commit criminal acts while in the jail and promising to kill someone when he gets out over money. So the state would just request that the bond actually be increased to $300,000.
Anything else to add? Anybody?
Nothing from the defense.
Did you want to add anything, sir?
Well, sir, I mean,
So we can hear you. Yeah.
well, sir, I do apologize for my acts or whatever, and I just ask, can you be real lenient? And we're asking y'all, can y'all be real lenient on me? Just ask for a bond reduction. There's a reasonable bond reduction. I mean, I miss what it said 75, I support 75.
All right. Okay, the rules for setting amount of bond are clearly provided under Article 17.15 of the Texas Code of Criminal Procedure. And it is to be sufficient to give reasonable assurance that the undertaking that the defendant would appear in court, in the court proceedings, and the power to order a bond is not to be used to make bail an instrument of oppression. Fairness is in the equation here. It doesn't, but that's what they mean. Be fair. the nature of the offense and the circumstances under which the offense are committed are to be considered. You have to look far and wide to find a more disturbing set of circumstances than the impregnant, the impregnating of a 12-year-old child here by you, a man who is what, 32 years old? And thus, the grand jury has charged you with this first degree felony, but in 2014, you were sentenced to 2 years in prison for the assault on a family member. So this offense is now punishable. If all of this is proven true, it is punishable by a minimum term of 15 years prison, up to life in prison. You understand that because of the prior conviction. So the bail was set originally, and we will assume that $150,000 was based upon the magistrate's determination that the nature of the offenses, the offense alleged is the nature demanded a high bond. If and we're talking about not only an aggravated sexual assault, but this is of a child of 12 years of age. So the law protects children who have been harmed, especially in a disturbing manner such as this. Also, the future safety of the victim of the alleged offense, law enforcement, and the future safety of the community shall be considered. So while you were in custody on this $150,000 bond, you apparently have been caught on at least 3 occasions threatening to kill others through the phone or text messaging system. And this is all shown through State's Exhibit 1, 2, and 3. And number 3 is, I never play you, I love you, care for you, and promise you about your daddy. So if I don't get my money, all my money, you have to pay with my freedom. And God bless you. You how it felt, and that's on my red mother's soul. I'm spelling words, and I just read that directly, but the inference, of course, is threatening. But State's Exhibit 1, which was a message sent out on August, look, you don't want me out, so I'm going to kill your daddy. I promise he will be. You took my money, so my grandmother, old man, got y'all. Well, that's very disturbing. And then later on that day, or earlier before that day, there was a longer message that included, let's see.
Oh,
So tell you, daddy, to look out. That's all I have to say. And then threatening people who are apparently involved in the accusation here in this indictment. These are threatening to kill others who are involved in a criminal case, of course, or criminal. And when you're doing it, even if you're sending it out from a jail, that still disturbs people. The safety of the community is at risk, which the law allows us to protect with bail. Bail was set at $150,000. Thereafter, these threatening messages are made by the defendant. And because of not only the charged offense, but his criminal history, he has been convicted of assault. So we know he is capable of, and this was assault on a family member. So we know the defendant is capable of harming others. And family is supposed to be your same blood, and those ought to be people you consider in a more affectionate manner than strangers. But that's not what Mr. Booker considers, and that's not what his actions have been. Then I'm going to grant the state's motion. Your bond is increased to $300,000, sir, due to these additional threats that are made in the jail. And if you happen to post a bond, you will be placed in a home confinement, but you cannot have any access nor communication at any time throughout this trial until it gets resolved with the victim or anyone who on behalf of the victim. And then I can guarantee that there would be no amount of money of bond that could be allowed if you a third time fail to follow the orders of the court. I think also the orders on behalf of the court to the jail that the defendant had no access to communication outside from inside the jail to anyone outside the jail via electronic means of any sort.
In Your
I
Honor,
think that's a global enough to include texts and phones, nor anyone on your behalf act in a way that defies this court's order.
and Your Honor, just to clarify too, the defendant was also sending letters, handwritten letters to the same individuals who were threatened. Just
All
to
right,
make
I'm
the court
sorry.
aware of
And
that. Yes, sir.
no communications at any time. Because of that, no communication is allowed to be sent out unless it is reviewed by jail authorities first. The orders of the court are what they are. But you can send out letters as long as they're not, you can communicate to people, but as long as they're not threatening nor to people that the court has forbidden you to send them to. And the jail has to review them because what you have done while in the jail is very disturbing, to say the least. Threatening to kill people.
I say hurtful things, she said hurtful things. I mean,
Sir, you're convicted felon of violence. You were convicted of a felony assault on a family member and was sentenced to 2 years in prison. Don't say you're not a violent person. You've been proven to be a violent person. You are a certified violent person under law. And you're only showing it worse by these threats to kill people after you have been indicted for one of the most serious types of offenses known to mankind. the sexual assault of a child. All right, is there anything I missed on
No,
dotting
Your
i's,
Honor.
crossing
No, sir.
t's? That is all. We're in recess on this case. All right, what else do I have, please?
The co-defendant Danielle Davis, Your Honor.
Her.
There's an issue with her.
Okay, so we're about to watch the co-defendant. It's great that they have them up back to back, and I'm going to give just a brief overview and a little bit of my words before we jump into that. But what a mic drop by Judge Stevens. You know, this monster says, I'm not a violent felon, and he just drops the mic. He drops it like, whoop, boom. You heard the courtroom shake with that mic drop, and he's like, you are a violent felon. You have sexual assault of a child. And just to give you a brief summary again, a recap of what happened in this case is that this monster and the mother's monster, and he's like the stepdad type figure, he's impregnates the 12-year-old. Mom knows about it the entire time. They have the baby in the home. Someone calls the cops about that. They take a DNA test and prove that it's him. While he's in prison, he somehow spends like $30,000 on phone calls and I don't know, soups. And it comes out through the recordings, which we're going to hear the recordings very soon, what it was that he was doing and threatening through prison. And this case has it all. And I just want to add one thing is that, you might have a hat tricks for being how evil you are. And he checks right every box. Physically harms his family members, threatens to kill them, sexually assaults, impregnates. He's only missing one crime on his docket. And that you might say, I think is harming an animal. Something else that we just can't stand, and have no fear, he checks that box too. On September 12th, 2018, he pled guilty to four counts of cruelty to an animal. Criminal District Attorney Bob Wortham announced that Booker was sentenced to 1 year in county jail for each count, so 4 years, sentences to run concurrently. This comes after Animal Services Officer Dustin Curry with the Beaumont Police Department responded to Booker's home on May 22nd, 2014. When he got to the home, the officer found on deceased dogs and several severely undernourished dogs. Investigation revealed that Booker was the owner of the dogs and left them in a garage for over a week without food and water. Prosecutor Ashley Shearer said, I applaud the dedicated work of Officer Caraway as well as the work of our other animal service officers. It is important that we prosecute people who commit such acts of cruelty to pet animals. I encourage members of the public to report any such abuse. So, when you thought it couldn't get worse, we find out that just one of the charges was having his dogs and starving them for a week. You can't make it up. And as the judge said, nothing surprises me anymore. But this is something new. And we're about to see that mother, if you can dare call her that. And not only that, Richard, as Richard pointed out here, and thank you, Sir Richard, for, of course, recording this case, recording it and researching it and making sure that the public, that the world would see it. But here it is, that Richard said, and when she told Mama what happened, Mama told her to shut up because he's paying the bills. So because he was paying the bills, the mother allowed him to do everything he did, including impregnating her own daughter. You can't make it up. We're about to see that mother in the flesh. I feel bad even saying those words, mother. Again, welcome, Biggin family, and thank you, Dame Piglet, for the 10 gifted memberships. It means a lot. We're going to go over details of the crime on this article here that Sir Richard found, but first, let's see the mom case and before we go over that in more detail. So here we go.
I have jail calls where she has called the victim, Malaysia Davis, and essentially she's tampered with the witness. She
Okay,
has,
is she on the docket today?
yes, sir.
Who's her lawyer?
Mr. Adams, he's, I think, back.
Okay,
But it's essentially the same kind of scenario where she's making communications.
all right, we'll deal with that one too. Thank you. Look, I'm going to, on Mr. Rollins, I'm gonna find you indigent so we can get somebody, people to help you, okay?
Currently has Mr. Dukes.
Yeah, do my best.
Okay. Yeah, Mr. Dusley will continue to assist you. We'll set that for an announcement, okay? Thank you. Get a reset, come get a resetting, sir. Thank you. Okay, this is who, Danielle?
I'm right there. Right?
Here's Mr. Rollins' file. There we go.
I'll just chat while we wait. It's running.
What,
Here, is that her coming in?
you probably need to talk to his staff, okay?
Jesse says probably an AC. What's AC, Jesse? You mean PC? Is that her?
We need Danielle Davis. Langston, we gotta have some hearings on that.
He'll be kept separate, says Jesse. Jesse spent, what, 7 years in prison? So Jesse knows. He's our
What else do you
resident
have other than
expert.
Is that it?
That's it.
Do you know what the nature of this hearing is?
I think it's,
You were here when we were doing this other hearing on the previous person?
I heard some of it, but not all of it. I was in and out. But I got an idea of what he's doing.
Well, it didn't work well for the previous person. Come forward. Are you Danielle Davis in 23 CR 889?
Thank you, Jesse.
You
Here
were
she
charged
is.
with the state jail felony of credit or debit card abuse. And Mr. Adams is here representing you. You're here for another reason, though. This court has received some very disturbing news and information from the jail authorities and the district attorney's office that you are involved in a pattern of threatening acts to others. You have sent messages of threatening acts, and those will be dealt with severely. What's they have to say? Can you explain what we're talking about here?
Yes, Your Honor. The state's been made aware that in their jail calls that were downloaded, that show that Ms. Davis contacted the victim in this case, Malaysia Davis, via her grandmother's phone number, who she's now, it's a Helen Schenkel. The victim is now the grandmother has custody of her, right to her, I believe, terminated of the parents. Grandmother has custody, and the defendant has been contacting the victim via that phone and asking her essentially to say something different than what the defendant has admitted to.
Isn't that kind of a crime?
Yes, Your Honor.
Well,
Tampering with
the
the
grand
witness.
jury needs to move forward
sir.
and indict
Yes, sir.
some additional charges. We're not going to put up with that
Yes, sir.
manipulation.
And ask her essentially to say that in order for her to be able to get out of jail. I have the call as well that I'll try to admit if it's not very long. So if the court would like to hear that.
Yes.
And there's also another call, and there's lots of them, but I just got the one. There's one in which the defendant contacts, again, Geraldine Davis. That's the same kind of group of the same individuals that were living in the same house. Paige Davis from the previous year. She contacts Geraldine Davis, and then three-way calls to Mr. Booker, and then they're communicating over the phone via basically both jail phones to each other. And so the state has brought this motion to, again, prohibit her from having any communications outside, not, so she can't tamper with any witnesses, as well as, again, communicating with the other, the co-defendant.
Are y'all proceeding on bringing forth additional charges in front of the grand jury to see if they will indict additional charges for this person's behavior?
Yes, sir, absolutely. I believe it's very clear on the jail call from what was said.
Have you heard these?
I've been provided a copy of it,
Okay.
but
In your honor, I would offer State's Exhibit 1. If needed, I can get Mr. Mentor up here to.
I just want to take them on a short, like 30-second board diary.
Were you here earlier on this other hearing? Because he testified as to,
No, I just want to ask him, just the one question is that can he?
come on up, sir. Thank you.
Yeah, I heard him. I was sitting down.
Okay. Because he sponsored the presentation of that.
Well,
Now, raise your right hand, sir. Do you solemnly swear or affirm all statements you make during this hearing will be the truth, the truth, and nothing but the truth, so help you God?
I do.
Thank you.
Can you say with any certainty that that is my client's voice on that recording?
Yes, I can.
And then how would you know that that's her voice?
When someone is brought to jail, they have to set up the phone system themselves.
Mhm.
It's a two-part identification system using voice recognition and an individual PIN. The voice recognition matched the phone call. I monitored several phone calls and they're all the same voice.
So when you say voice recognition, your computer system, like Langston Adams, right? My voice is distinct from your voice.
Right.
So the computer system is gonna be able to say, this is Langston and it is not Mentor.
Right.
And what you're saying is your computer system saying that that's her voice and not some other person's voice.
Yes.
But that's not all, right?
No.
There are other methods you have.
They also have an individual PIN that the inmate sets up. It is
Okay.
unique to them. The connections that they make on the outside are also approved through them.
Mhm.
So everything ties in together. We match all the phone calls with the voice recordings.
So you're saying that in addition to the technology to identify the voice, the inmate has to type in a particular PIN that's only associated with that inmate, right?
Yes,
And in this recording, are you saying my client typed in her particular PIN?
yes, she did. It's the only way she can access it.
And what was her PIN?
I have no access to that. That's individual to them.
All right.
Anything else?
Mm.
Your honor, state would just, oh, sorry.
You know, you're going to introduce.
Yes, sir. Your honor, the state would offer State's Exhibit 1. That's the jail calls.
Okay, any objection? I'm not saying we have to listen to it. I think you've got access to it. But
Right.
it's for the purposes of this hearing and for the court's determinations on rulings from the matters in this hearing.
He's saying that it's less than a minute, something, so I don't.
Well,
we're gonna play
This
it,
one,
play
these
it.
are actually a few, these are probably around 4 minutes, something like that, each of them 4 or 5 minutes. I only really want to play one of them, but I'd want to admit 2 of them, but just play the one where the witness was actually tampered with.
That's fine. If you gonna just play the one where he's saying that the witness is tampered, that's the most important one. That's the one that I'm more concerned about.
Go ahead.
Yes, your honor, asked to play that for the court.
Yes, you may. State's Exhibit 1 is admitted for this hearing.
Thank you.
And again, your honor, just to provide the background, this is a phone call made from the defendant Danielle Davis to her mother, Helen Schenkel, who is the custodian and the guardian of the victim, Malaysia Davis now.
He said Helen Frankel,
Schenkel?
Schenkel.
Yes, sir.
And you said that my client called Schenkel, and then Schenkel in turn had the kid on the phone.
Right, the defendant asked to speak with the victim and the
Okay.
victim was allowed on the phone. That has been addressed with the grandmother as well.
This is a prepaid call from Danielle Davis, an inmate at a correctional facility Three-way or call waiting is not allowed and may automatically disconnect this call. This call is also subject to being recorded or monitored except for privileged communications between attorney and client. Please select from the following options. If you consent to this call being recorded and to accept this call, dial 1 now. To reject this call, dial 2 now. Your call has been accepted. Hello?
Hey,
Hey, was you asleep?
no, I'm trying to keep this baby on.
Oh,
Give her a breathing treatment.
who, Julia?
Mm-hmm.
What's she,
And Your Honor,
mean a breathing treatment?
Jalea is the baby of the 12-year-old.
Oh, okay. When Malaysia?
They have to back down somewhere on good kids, back down.
Let me talk to her for a few seconds. Malaysia!
We'll see the previous file, please. That previous case, thank you.
Let me get them on.
Who?
Yeah. Well,
Hey, why you taking so long to come to the damn phone?
open my room.
Huh?
Open my room.
Why you sound like that?
I just woke up. Nothing over.
You been good?
Mm-hmm.
You sure?
Mm-hmm.
You positive?
Yes.
All right, I love you, little stinky butt.
Mm-hmm.
Yeah, you do. You think I could speak through the phone?
Mama,
What? Malaysia Nicole.
that's not my wife.
Keep thinking.
No.
I talked to Aunt Renee yesterday.
You did?
Yeah, I think she's gonna call you out later, either sometime today though.
Mm-hmm. Did you
Yeah.
talk to Richard?
No, but they was going to vacation Bible school, but I heard, Jordan over there terrorizing them.
It's bad.
That's what she was telling me. I
Yeah,
heard she like, Jalea with the little twig in her head.
mm-hmm. Julia likes it.
Huh?
Julia likes all of the shit that be running for me.
Be running from them.
Mm-hmm.
Why you be running from them?
I don't know, because she's walking out and she's trying to get in the hood, and he'd be running from me.
But you doing all right?
The right accent.
You doing all right?
Mm-hmm.
Yeah.
So,
What you mean, so?
like every now and then I have breast stuff, other than that, I'm fine.
It's gonna be all right, okay?
Okay.
You should have told me from the get-go when the first day ago.
I know, so,
But I understand he threatened you and stuff like this, so I know you scared.
mm-hmm.
So you go, I don't know if they gonna have you come to court and testify or whatever, but you need to let them know that you didn't tell me until the last minute.
Okay.
My mama could get up out of here.
And Your Honor, just to be clear, the defendant has made admissions to detectives and interviews that she knew well ahead of this, that things have been going on. I think up to potentially 2 years ahead of this, that she was
When
aware.
you say things have been going on.
That she had been, the victim, Malaysia, I'm sorry, Your Honor, Malaysia Davis had been being sexually assaulted by the defendant, Mr. Booker.
But my brief response is what you actually heard with your own ears, because I was listening just like you, I saw you was listening, is that what I heard the little girl and the mama say is hey, basically, you just telling me about this and to tell that truthfully in court.
I mean, you heard what the lady said.
Is that the end of the conversation?
No, Your Honor,
You
I'll
heard it?
keep,
Let's listen
I'll
to the
keep
whole
playing it.
darn thing.
Because to me, that don't sound.
Let's listen to the whole thing.
And
first.
she also says right after that, so I can get up out of here. That's different than her statement to the detectives. Also, the victim never said that her mother didn't know until that point. So she's now providing her with information which she needs to tell them, which she told differently to the detectives.
Because you heard it with your own ears. That wasn't no threat to the kid. And
This
I
isn't a
didn't get no-
debate, everybody. Let me hear the evidence
Yes, sir.
first before everybody starts arguing at one time, okay?
Right, right. I'm just
Okay,
saying.
otherwise
Right.
chaos. It's not
Right,
gonna
right.
be chaos in this room.
Right,
Some
right.
order for a change.
But,
Yeah,
no, I'm
like,
just trying to
like
make it.
kindergarten class all shouting at one time. You
Yeah,
don't
yeah,
do
yeah.
that. Let me hear the evidence before everybody sounds in.
Right.
Jeepers.
So, okay.
My mom could get up out of here.
Okay. So,
I don't know.
so, how does that work, Mama?
I don't know. They're probably gonna call you for it.
Well, I'm saying that, how does that, wait, what would happen if I just bug into it? What would happen?
He'll go to jail.
Well, I know that, but I'm saying, like,
She'll go to jail for a long time later.
that's what I was trying to basically say.
Yeah. If they got you testifying against him,
Hold on, Mama, Papa call, hold on. Well, Papa.
hello? Hello?
That's essentially the end of it, Your Honor. She never gets back on.
Well, Judge, my position is if that's the end, the call actually helps me. It don't hurt me. Because if you listen to the call, and my argument would be, she begins the call where she's concerned about her child.
Right.
Hey, how you doing? You know, what's going on, et cetera, et cetera. And then in the call, I know you heard, Judge, she's talking to the little girl and telling the little girl about how the guy you had in the courtroom, she's acknowledging that dude has been threatening you, not her threatening the child, but that dude was threatening her. And then she goes on to say, I know you heard it, she goes on to say that, hey, I'm really just finding out about how he was threatening you. And then are you going to have to testify in court? Yes. And he is going to get a whole bunch of time because he's got to testify in court. There's nothing in that call I heard where she is threatening the little child. I didn't hear that. I didn't see a threat coming from her.
Your Honor,
So in the argument that I'm making is, in a sense, when he played the call, that call is not what you got in the last hearing. In the last hearing, what you got was somebody with text message saying, "I'm gonna kill you." You don't get that in this. In this, you don't get anything close to that in this. In this particular case, in a sense, that call kind of helps because, in essence, she's saying that the man gonna get a whole bunch of time for what he did. So that's not tampering. That's not saying come to your court and go lie to Judge Stevens. That's not saying, hey, don't come to court and testify against the man that's gonna get a whole bunch of time. That's not saying, hey, I'm gonna hurt you or do you harm. Actually, I think the call helps me.
All right,
Your,
your point's
helps
been
me.
made.
Your Honor,
You
and
stay safe.
they don't have to threaten, it just has to be influence or in any way. So again, that's not really that relevant that what a threat. It could be to influence them. And it certainly did. The child victim has been calling the court staff saying that the child is not his, not Mr. Booker's, constantly after she heard from her mother that he was going to go to prison for a very long time. Ms. Davis also,
Let me just ask a side note.
Yes.
At the end of the day, certainly y'all have DNA evidence.
absolutely, Your Honor.
That would be scientific, that is going to overcome any individual's testimony about whose child it is.
Yes,
It's
Your
going to be scientifically DNA determined, and that's just the way nature is. I mean, that is going to bypass really the weight of individuals. I know the point you're making. You can end because number one, you're talking to witnesses, potential witnesses in a most serious type of case, sexual assault of a child. Number one, you don't know if that man is going to go to prison for a long time or not, because you're not going to be the jury.
Yes, sir.
And you, unless, yeah, the only thing I think you really know about the law is maybe Law and Order reruns,
Yes.
because you're not speaking intellectually about this. Number one, right now, that defendant is presumed innocent under the law.
Yes, sir.
Number one, number next, you're presuming something that hadn't happened, that's in it, not in your power, that he's going to be found guilty. Number two, that he's going to be sentenced to a long time. He might be, but he's presumed innocent. Unless that happens, you're the last person on the planet who would dictate what would happen. Number next is, this is a child that was 12 at the time of the event, so it's maybe the child's 13 or 14. By talking to the child about what could happen and a lengthy prison term under your limited knowledge, about this, you're very limited, and I'm being nice about this. We call this ignorance of the law. You're ignorant of it because that's not the way it works. You're not the determiner. You're just making a prediction. But number one, why are you doing that? There can be only one really obvious reason: to make her feel guilty about coming forward and testifying. Because now you're going to interrupt me? Because he's a 12 or 13-year-old child. I've got children. I had children, little, and they've grown up to be wonderful people. I was a child. I know how children are. They're influenced by people who are close to them, like you. You got no reason talking about this case where she is a vital component as an evidentiary matter in a most serious case, a victim. But you're telling the child, the guys, that person is going to go to jail for a long time. Little children think of prison in a horrifying way. They don't think it's a good place. I don't care what they might be victimized. Children are more forgiving and don't want horrifying thoughts, unlike adults who thrive on that. All that could be done. All that you were doing is trying to make her feel guilty about being a victim and having to testify later, because you were putting on her conscience that going to prison a long time would be her fault. Wrong. That is forbidden in front of me. That's almost sinful. You got no business making her feel bad and talking about what could happen, because you're not in control of it. You're the last person to be on a jury in that case. You'd be the last person on the planet. You'd never get on it because by law, you're too close to it. But it's obvious what, as an objective listener, what you were trying to do, make her feel guilty. So you have lost your phone privileges as well. And the jail is going to monitor. You can speak to your attorney. That's it. But this tampering with witnesses maneuver, that for the second time I've heard on a most serious case, which is so transparent and so obvious, is not going to happen again. You've lost your privilege. You understand?
I think I think she absolutely, and I agree with you.
Well, we'll see whether, I don't know if she understands or not, but it's the order of the court,
No,
and you violate the order and you'll be in more trouble. And is the grand jury considering indicting her for some additional?
So we're gonna have to
charges?
get an investigator to write up a statement over this and present that to the grand jury, get one of the officers or investigators to do that. I just got a lot of this information within like the
Let
last
me
week.
ask, what's her bond in this case?
It was 100,000, Your Honor.
Mhm.
And also, Your Honor, I would just note that Mr. Booker admitted on the stand a while ago that both he and Miss Davis were taking funds off of the victim's child support card and using for their commissary. The only way for Miss Davis to do that was to use these communications outside, calling Paige Davis to get her to do that for them. So that's another
She's lost her
reason. Yes,
she's
sir.
lost all phone privileges except to be a lawyer.
And Judge, like I said, in the conversation that was inappropriate. But, and I'm not arguing that point, but just based upon what was said when we started the hearing, no, and he's just following my logic. To my understanding, the state's position is that she somehow tampered with the witness by threatening the witness, one, and then hold on, and then in the reading of the motion, and I read it word for word, trying to get the witness to testify untruthfully. On neither one of those points did I hear a threat, because I know you was listening too. Did I hear a threat that came from her, one, and then two, I didn't hear anything where she told that little girl, you get to court and you go lie and testify truthfully. The only thing she said was, is this dude here, he's gonna get a whole bunch of time. Now that's not saying testify untruthfully. That's not saying go lie to the judge. And you heard, so on the things
You made your
that,
point, you
yeah.
made your point. A reasonable inference from this can be drawn,
Mhm.
and that is not making the child feel guilty, which would cause reluctance for the child to testify. That's not right.
Right.
And she's speaking about things that she has no authority of any.
Right.
She doesn't have the authority, so why would she pull that out of thin air? She doesn't have that authority. It's a jury to decide whether he's guilty or not for the first place.
Right.
And then a jury to decide, because he wants a jury to determine how much time, not you. And to somebody close to tell a child, he's gonna go to jail for prison for a long time. I was a child too, and I know what I would think of as a child. I know what my children would think of. They think prison is a horrifying place. It ought to be thought that way because there's nothing good about it. But it was in this context only reasonably. You can only reasonably state that you pulled that stunt to try to intimidate the child in testimony later. And that would cause the child reluctance to come forward because children by their very nature don't want to hurt people. Unfortunately, adults evolve. Some adults evolve different from their child behavior, their child instincts. But the innocence of that child, which has been lost in the first place when she was impregnated, is further being tampered with. And I'm not going to put up with that. I'm going to protect little children to the end. And we're going to, this whole due process of law is not going to be interfered with by people like you who don't know any better or don't act any better. Your privileges are lost. On the money thing, this using money,
Yes.
what is the state asking for in a remedy? Because I'm going to deal with it.
As far as that as well, Your Honor, we would request that also the bond be increased, but we'll certainly try and see how much money was on there to try and look at potential restitution on that, as well as contacting the civil court that ordered that and making them aware of that and seeing what other potential criminal acts were out of that.
All right, I've heard enough to believe that this bond should be increased by what is obvious an attempt to tamper with a witness. I want to know though, there are these, I am limited from what I'm hearing here,
Yes, sir.
but it's for additional, the executive branch of government and either misdemeanor charges or grand jury review that needs to move forward
Yes, sir.
on some other matters to
Yes, sir.
add to the mess that I've heard about already that are in these indictments. We've got additional problems that are being perpetrated in the jail. And that's another reason I'm going to do my best to help the jail employees and the jail personnel ensure that it is a safe environment, and also it is not an environment where additional criminal actions are perpetrated. And I will take extreme actions, and you have now been, your voice has been stifled. You're not going to be communicating except through your lawyer. And then that is the only method, unless there's something that the jail personnel can determine where they listen in. But first of all, it's pretty foolish. Doesn't everybody know over there that those phone calls are being recorded? I mean,
Yes, Your Honor.
why would you? What person with any amount of intelligence at all would start risking further criminal liability when they're being recorded? But generally, the people in jail have made foolish decisions to get into the jail, and I don't expect them necessarily to change their foolish behavior when they're in jail. But your bond is increased to 200. It's double. On what I heard, that is a criminal act of trying to tamper with a witness. Your bond is increased to $200,000. If you post a bond, you will be at home confinement and GPS, and will have no contact at all with that child, victim in this case of what the Mr. Booker was charged with.
Yes, Your Honor.
And no one on your behalf will have any contact. I find otherwise, then we'll deal with that. And the problems just keep doubling each time. We're gonna have people following the rules. Do you understand? Or else you will pay a high price. And when you're tampering, when we're dealing with children who have been victimized like this, I'm going to protect them and hold people highly accountable, and it's going to sting. I can't imagine this kind of a poor child having to go through this. Your behavior has to change. And you have to start acting more like a family member. That's a loving family. That is supposed to represent, as an adult, good role modeling for the children. You're not. Anything else to add? What are we doing about a trial or something?
Yes, Your Honor, we'd asked to set it on the trial docket. We'd been kind of waiting on Miss Davis for the other one to go to trial, but we'd go ahead and set it for the
All
trial.
right, it will be done. And Captain Minter, anything you want to add that in this situation that you feel like the jail needs on behalf of the court under any kind of orders that would ensure that the jail personnel are being able to do their job efficiently?
I'll need the appropriate paperwork to turn off everything for both inmates. Everything that's needed, postal mail.
Okay, who's going to prepare that? I guess.
I could get with the staff, go over that, Your Honor, if you'd like me to, as far as all the communication, except for with the attorneys, correct? Through the, okay.
Is a memo that I sign?
As long as it's signed by you, sir. Yes.
Yes, sir. That shouldn't be good. Langston, anything you need on behalf of your client here?
Well, as long as they keep the communication open with me and her, I'd be fine.
Yeah, that's, I'm not gonna mess with the Constitution.
He'll be able to talk to her and book him either through Zoom or personal.
Yeah, we just want to make sure that it doesn't go out to the people other than him.
It'll
And
only
I
be-
trust him. I trust him. I just don't trust you, and from what I've heard. Anything else? We are in recess on this. Thank you.
All right, thank you, Judge.
You can. So what?
Wow. I mean, what a judge. Imagine if our courtrooms were packed with judges like this. the world would clearly be a better place. You know, we see a lot of hearings, and sometimes you get a mic drop, sometimes you get two. But do you ever have a hearing where you get one after the other, after the other, after the other? Really, like, we have enough here where we can make shorts of this judge just laying it down, saying what I think most of us are feeling and thinking and wanting to say. And to see a judge just lay it out, it's therapeutic. It's chicken soup for the soul. Because I mean, what were some of the things he said? He said, "I'm going to protect little children." You know, and he looks at her in just the complete disgust and shock and at the mother, and he just tells her what's on his mind without any filter. And he had a really funny line in there too, and he said the only thing you know about the law is Law and Order reruns. I mean, maybe that should be the title of this premiere. And he just couldn't get enough of it. He's just like, how dumb are you? You know these phone calls are recorded. And she has her attorney that's going to bat for her, trying to pull every stop. And it's like, first he says, that's not her on the call. How do we know it's her on the call? Which is I mean, come on, really? I mean, it's recorded. They have the documentation. And then all of a sudden he forgets that excuse and he says, Judge, look, I mean, see, she never said, this is, she never actually threatened her daughter. This phone call actually helps my case." And the judge is just like, what are you guys, let's just listen to the rest of the recording. What are you guys even arguing about? And they listen to the rest of the recording, and the attorney still says, no, see, it helps my case. And then while the judge is doing the monologue, he comes in to interrupt him. And then, like a school teacher admonishing a student, the judge just looks at him and says, "Really? Are you going to interrupt me?" The judge was done. It was done. And I mean, it was just the most beautiful thing to see how he just picked it apart. And then I think we also need to give a ton of credit for the DA in this case, the ADA. I mean, the ADA came prepared. He had immediately in the initial case, the defense attorney says, brings something up, and he had the jail guard ready. I mean, they didn't have to call him in as a witness. He knew he was playing 3D chess. He had the jail guard sitting there, and he brings him up, the captain. I think it was the captain, right? And he brings him up to testify right there in the spot. And then the ADA also had those recordings already. You know, he didn't have to search for the spot. It was all done. He pulls it right up, gives it to the judge. I mean, this thing just ran so beautifully. And to see the ADA do that, actually caring at this point, actually making sure that nothing's going to slip through. I mean, how many hearings do you see where two people come in asking to have their bond reduced? Instead, it results in the bond being doubled and tripled. It's just a beautiful thing to see. And welcome, Lisa, as a new member. And thank you. We have also, I just want to give shout outs and thank you to Mr. Jeter for the 5, and we also have the 10 memberships at the beginning. Thank you very much. So let's go read over this article. And thank you, the 10 memberships from Piglet. And thank you, Sir Richard, for recording this and bringing up this case and doing the research. Now let's just read through this. If any had any questions, maybe this can, oh my gosh, bring some clarity. So couple charged with aggravated sexual assault of a child is April 9th, 2024. You know, they almost look, a couple, they could be like brother and sister. Right? A couple both accused of aggravated sexual assault of a child in their care that resulted in the birth of a baby appeared before Jefferson County Criminal District Court Judge John Stephen on April 1st for announced hearing. I hate the ads. Hold on, let me see if I can get. There we go. Joshua Booker, 32, and Danielle Davis, 30, of Port Arthur, both currently reside in Jefferson County Jail. I love how they say that. They both reside in the county jail on charges of aggravated sexual assault of a child, which resulted in the pregnancy of a child younger than the age of 14. To be clear, she was 12. According to the affidavit of their arrest, and this child was her daughter. The police department BPD Detective Franklin Coffin III was dispatched to the Medical Center of Southeast Texas on August 12, 2022, in reference to a 12-year-old who had just given birth. The baby was delivered. Doctors believed at approximately 37 to 38 weeks gestation. Estimating concept occurred around the first week of December 2021. During the investigation, the juvenile home members reported that the male who impregnated her was an adult family friend or cousin. However, Child Protective Services (CPS), the investigator, advised Coffin of inconsistencies with the family's account and that she was leery of this and suspected Booker to be the father of the child. So they made up a story and said, "Oh no, it was a family member or a cousin," but hey, CPS smelt a rat, and good on CPS. The child's mother was later interviewed at Garth House, and according to the detective, it was clear that the victim had been coached. Davis, who was legally responsible for the safety of the victim, later responded to the police department to speak with detectives. At first, Davis denied knowing the juvenile was pregnant, or even who could have been the father. Davis later admitted to detectives that Booker was the father, and she had not notified the authorities because if Booker was arrested, Davis would have lost his income as the two were partners. Thank you, Carly, for the 10. Thank you so much. That is so generous of you. Thank you. Can you believe it? She's like, and just the judge just lays it out to her and says it straight up. I mean, and I saw many of you in the chat saying, "Oh, she's pimping out her daughter," and yeah, that's what it is. That's what it is. Now, Davis advised the detective that she knew Booker had been sexually assaulting the juvenile approximately 2 months prior to the juvenile getting pregnant. And by the way, this juvenile is her daughter, because the victim had made an outcry to her. Davis stated that she instructed her daughter to lie to investigators about her outcry that Booker had been sexually assaulting her and fathered her child. Davis reportedly made no attempt to protect her daughter she was legally obligated to protect. Booker's DNA was collected and matched as the father of the infant child. And I do wonder, this fool is going for a jury trial. How is he going to get out of this one? Oh, he's going to have the attorney show. The DNA, it's DNA. I mean, look, we'll use the same attorney from the part in here when you saw my client took a lie detector test, and that DNA, it can't be true. DNA is not an accurate science. DNA, it's kind of like this misinformation thing. It's not true. I don't know, what's his attorney gonna say. Just when you think humanity cannot get any to a lower level, they dig deeper into the ground and seek a lower level of existence. We're talking about a 12-year-old giving birth and no one coming forward with the truth on how the child became impregnated. Stephen observed and scheduled subsequent hearings. I mean, this is a classic. I mean, Judge Stephen is just so eloquent. You know, you just could tell it's a Judge Stephen quote. Booker's court-appointed attorney, Donald, advised Judge Stevens that his client wished to have a trial separate from Davis. I do hope that Judge Stevens is the judge for this trial, and I hope that it goes to trial. I hope that they don't do some plea deal. And by the looks of this ADA, I would like to think that they're not gonna give a plea deal. They seem to be prepared. They seem to be angry, and I hope that it's not agreed on. I hope that they go to the full extent of the law because, sadly, we have seen cases where there is DNA evidence because a baby is fathered, and they go to plea deals. We've seen it many times. We've covered those parole hearings, and it always outraged me because it's why are you doing a plea deal? You're holding the royal flush. He is guaranteed prison. And they still get plea deals because they're lazy. And hopefully in this case, by lazy I mean the district attorneys, and hopefully in this case, that's not going to happen. And one never knows, but Richard's going to be keeping track of this, and we'll only know which judge has it when it goes into docket, and I assume it's going to be a long time until a trial takes place in this type of case. But man, I mean, I felt like the attorney for the first monster. I felt like he was I almost embarrassed to be covering his clients, and he's just doing what he had to do by law. He wasn't overzealous in his defense. But the second attorney covering the woman, I felt he was like, being zealous. He was gung ho. He's like, Judge, we don't even know it's her on the phone. And then when they bring out the evidence, well, Judge, she's clearly not saying anything threatening. And I mean, just think about it. And then it's also kind of just an odd wrench in this case that covers everything was all the money that this man came up with in prison. I mean, who can take what was the number of total phone calls that he made? I mean, he spent like 30 grand over the period of was it a year on commissary and phone calls, and it's like, how? I mean, he was taking all of their money, but even then it's like it just shows how impulsive like 30 grand, that's a lot. He's not gonna be able to come up with more money. I mean, the money's gonna be gone. Right? Like, it's not gonna be like, and how long are you spending on the phone? Who are you talking to? What are you doing? 6,200 phone calls. Thank you, One Love. Thank you, Phyllis. Thank you, Tam, for all coming in with that. 6,200 phone calls. You guys' memories are much better than mine. Piglet says it must be a narcotic dealer. Maybe. I mean, but to be a narcotic dealer and then to save all that money, I mean, that would be a pretty effective dealer, to save all the money and then, but now to blow it. It just doesn't add up to me. It's like, you can't be both things. You can't be frugal and then frivolous at the same time. Welcome, Gelt, new subscriber. I just started watching your videos today. Just tune in. Good videos. Thank you so much. Welcome to the family, Doc. I hope you see you more often. We have premieres on channel 1 at 7 p.m. Eastern Standard Time, Sunday, Monday, Tuesday, Wednesday, and Thursday. And then we follow it up with the premiere on Mandoo 2, typically at 8 p.m. Eastern Standard Time, so an hour later. But not always. Don't do a lot of lives. This is an exception if you're new. Usually it's premieres, so we have the live chat. Here we have Mr. Jeter. These are the type of cases where we should be able to do without due process. I know once there's I agree. It's like there's DNA. And I get it. You still need due process, but what I don't like about this is if they're gonna call up the 12-year-old, and it's like really, you're gonna put her through that when you have DNA. It's a good point. Sir Brighton, $2. Sir Brighton, awesome commenting, Mandoo. Thank you. So Brighton is going to have a premiere right after this. Someone could drop the link in the description. We'll all head over there after this to check out Brighton. Nicole came in and said 6,200 as well. Northwest said 6,200 at $3 a call. So do the math. When the judge heard this, he was like, "What? $3, 6,200? I mean, he spent like 20 grand, 19, whatever the math is, 18 grand, and blah, blah, just on calls. Like, what is he like? What are you doing?" Who's pocketing that money on these calls? Is it like 18,600? Is it the jail that profits, or is it like some third party, for-profit company that gets the contract through, classic? I wonder how that company got the contract to charge $3 a call for the local jail. What a gig that is, huh? Like everything else. Private home company. Such a scam. The money from these calls should go to the victims. That's what I say. Third party, but jail gets a cut. It really is. I mean, who does it benefit for a third party to charge that much in profit? Like, really? That doesn't make any sense. These are things that probably could be fixed. And I say jail gets a cut, but I wonder. I would love to see the contracts of those deals because it costs nothing to terminate these calls. All calls go to cloud, and staff have to review them, etc. Especially using court, then have to pay for voice, etc. Okay, so there's an answer there. Thank you, Sir Richard. That is a good point. It is expensive because they're sending the calls to the cloud and recording them, and then they have to review it. So that okay, that's they're trying to justify the cost. That's interesting. I didn't think about that. That they're going to have now AI just doing it, which would reduce. It's an all new industry. What AI will do, right? You'll just have it listening to all the calls, looking for keywords. Maybe they're using it already. Yes, because my daughter used to work there, says Nicole. Either that or AT&T. You can't call adult from jail. Brighton, you guys dropped the link for his premiere? When is it starting? I see it here. Thank you, Christina, for dropping it. $20 for 15 minutes. National fee. Well, I mean, I feel like for this hearing, I want to repackage it because the live streams are not as, I feel like, as boom as when I edit it and do recordings. But this one, I just want to take those mic drops from the judge and package it into like a 1-minute highlight reel. Can you imagine this monster also did that to his dogs, where he starved his dogs for a week? I mean, he's done everything that you can do to be as evil as he is. And it almost makes you wonder how he hadn't gotten more time previously, like how he'd actually been free for so long. He's clearly a very unintelligent, dangerous criminal. It's like, how do you go to almost age of 40 without? Makes you wonder. Maybe do a weekly live. So I'm able to do. I'm sick of the commercials also, Pick, but I'm sorry. I'm the reason I'm able to do live now is because I'm on the road. It's hard for me to do lives when I am home, and that's why I do the pre-recordings, because when I'm home, I do the whole dad duty thing. We have, the dinner and the story time and the bath time, and I'm usually doing a multitasking. So I'm doing chat. I'm there. I'm watching, as you guys know. I'm doing the polls. I'm involved. I look forward to it every day, but it's to do an actual live. It's difficult. It's hard for me to do it. But I'm alone right now, and that's why I'm excited to do the live chats. Who's Judge King? Sonia asked about Judge King. Yeah. Yeah, they are harder, Brayden. Some people only there, in some there's two things about the lives that's interesting. See, when I don't do live and I do a premiere, I'm actually investing double the time. So premieres take much more time. I get the footage. I download it. I edit it. I find the highlight reel. I cut out what I think is the best highlight reel. I edit it into the front. I do my I do 3 separate recordings, editing, then I package it, then I put it in YouTube, then I do then I finally set the premiere. And then and then I show up when I'm done and I'm in the live chat and I get involved. So if the premiere is 1 hour, I'm investing all the time. So first I listen to it, right? Then I edit it, then I upload it. So now I'm like maybe an hour and a half, 2 hours in, easy. Then I listen to it at the premiere, so now I'm 3 hours in. Now a live stream, it's much easier. I just turn it on and I go, and I'm here. And I still have to think about it. What am I going to do as an opening statement? And but Richard does all the research. Richard does the article. So a live stream, it actually is a fraction of the effort and time. But I think that it's a higher quality recording when it's not live stream, in terms of anyone who comes in and just wants to listen to it. I don't think people want to hear me talking like this. I don't think people want to see necessarily the pop-up message. It's just a different experience. I know I'm not crazy about listening to live streams on YouTube. When I'm just listening, occasionally if I find something, it's like, live streams are, the intro is really, when I click live, it sometimes it takes 10 seconds till it goes live. Sometimes it takes a minute. So I never know. So that's why you see the awkward delay at the beginning, where it's this long delay where I'm like staring at the screen waiting for it to start, because I don't know when it starts until I see my screen, and this awkward long delay. They don't have a fix for it. I don't know. Thanks, Evolving Media. There was a field trip with kid and a 16-year-old fell asleep, then it went south in the courtroom. What's this? I'm not familiar. Where did I miss? Judge King. Thanks, Crazy Cat. Meow. Still good content, bro. Barely subscribed not long ago. Pretty cool to have caught you live. Thanks, Cheeto. Welcome. I'm so happy that you're here too. I miss story time with my kids. Yeah, story time's fun. Carol says, I love the lives. Good night, Nicole. Good night, Christina. Lives also for me hit a little different on the algorithm. I feel like the regular uploads get more views. So I'm probably going to repackage this and re-upload it and whatnot. So also, I know that I sometimes do repackage and re-upload, and I hope that you guys don't think I'm doing it just for the, because I hope that you don't think it's lazy or I'm trying to like click grab. I do that often when I see that a certain hearing just doesn't get a lot of views. Maybe it gets a fraction of what one normally gets. So I'll do that. And sometimes it works. So Richard just dropped the link to go to Brighton, and that's starting in 6 minutes. So I'm only going to talk for another 5 minutes, and then we're going to go jump over to Brighton, and I'm going to then eat dinner. Jam Jam says, sorry I was late, guys. I love these lives. Yes, Mandoo. And thank you guys, Mandoo, for donating to Jam Jam's GoFundMe. Jam Jam, if you want to drop the GoFundMe in the link one more time, please do. Jam Jam went to the hospital today to find out, and they're scheduling a surgery. All Jam Jam, her husband, and her child are all going through something, and pretty rough times. So yesterday, there was a lot of donations. I know it means a lot to her. Carla says, I enjoy your commentary. You almost had me in tears tonight. Thanks, Carla. I don't know what if I did to get you in tears tonight, but the judge had me, Judge Stevens had me laughing hysterically. I don't know about you. I literally broke out loud laughing with the amount of zingers the judge dropped down with. The Law and Order one was just classic. The only thing you know about the law is Law and Order reruns. And then the statement he says about I'm going to protect little children. The end. I mean, he even the end. That's what he said. I'm going to protect little children. The end. That could be a title too. Maybe I should change the title. I have a hard time coming up with titles, and titles could be 50% of it in YouTube. Titles and thumbnails, two things that I'm just not good at. And maybe I should invest in trying to get better at it, because maybe that's why the channel's struggling a little bit. I don't know. I can use help. If any of you think of titles, also, if any of you have sent me an email recently, I haven't responded. It's because I've been driving. I'm not ignoring you. I will respond to the emails. And if I don't respond, just send me a reminder. Go in the same email and say, hey, man, dude, topping up your inbox, because I am not ignoring you intentionally. You could ask us to vote. Vote for what? Thank you, Jam, for dropping the GoFundMe. Jam just dropped the link. If y'all want to check it out, let's go check it out now. Let's see if there's anything new. We're going to sign off in about a minute to go to Brighton as well. Let's see. Oh, no. Whoops. That was it when he said that. So yeah, there was a lot donated yesterday. So we had yesterday we had it was pretty funny. We had, so Debs gave 10. Elix topped that with 25. Lori came in and said, no, I'm going to do y'all better, and hit 30. And then Sharon came in right on top and said, no way, I'm getting the trophy, and dropped to 50. Chris and Reese just a little bit while ago with 20. We had Joyce with 15 and Janet with 10. You guys are just amazing. Janet came in again with, and most of you are donating now for the second and third time. Just a beautiful thing. And so thank you so much for that. Let's see. Brighton's premiere is going live in 2 minutes. So let's all go over to Brighton's channel. Best title for video. What's the best title? Oh, to vote. Well, Dame, it's hard for me to do that because I don't really know how. It's hard. How do we vote? How do I create that system? It's difficult. But if any of you see a title that you think is good, email it to me, and I'll use it if I think it's good as well. Honest Doubter says, we want you to succeed and have these important hearings seen far and wide, whatever they need to do. Thank you so much, Honest Doubter. And I know you guys do, because if no one watched it, I wouldn't do it. But you all watch and you leave amazing comments. And it is the most rewarding thing that I've ever done in my, I guess, not being a father and a husband side of my life. It's rewarding because the you get the endorphin hits from seeing all the comments come back. And I've always said, I have only received very special emails and comments from survivors and victims involved in these direct hearings. I've never a single time had a survivor or victim from any of these hearings ask me to take down a hearing. Not once, which is saying something. It might one day happen. And believe me, I'll take it down as soon as they ask. But the only people I've ever asked for a hearing to be taken down are the criminals or the criminals' relatives. That says something. Maybe that says all you need to know. So, yeah, we'll keep doing this. And Brighton's premiere is going to be starting now. So I'm going to end this stream. Thank you all for being here. Thank you, Sir Richard, for recording this hearing, making sure that the world was to see it. Thank you, Jam. Thank you, Carol. Thank you, Christina. I love you all. And with that, I'll let you go.